Good afternoon, my name is Ronaldo Hilton, the chairperson designee of the New York City Loft Board. Welcome to a June 20th, 2019 public meeting. Section 282 of the New York State Multi-Dwelling Law establishes the New York City Loft Board. The board is charged with overseeing the conversion of interim multi-dwelling buildings from commercial and manufacturing spaces to safe, rent-regulated residences that comply with the minimum standards of safety and fire protection stated in Article 7B of the New York State Multiple Dwelling Law. To achieve this goal, the board adjudicates and mediates disputes between owners and tenants, tracks the progress of each building undergoing legalization, and prosecutes parties who violate the loft law and the loft board rules. First turn our discussion to a request for a designated substitute for owner representative on the loft board. The board voted last month to revisit the question of whether the board wants to accept Jason Frosch as substitute for Mr. Carver, and if so, to what extent he can participate. Ms. Balsam will briefly report to the Loft Board about inquiries we made to the Law Department and the Conflicts of Interest Board.
So we reached out to both the Law Department and the Conflicts of Interest Board. The Law Department was concerned about a breach of attorney-client privilege, the board being the client, staff being the attorneys, in the private sessions, and felt that that information should remain confidential. They were not as concerned about public sessions, as long as Mr. Frosch would not be commenting on his own cases, obviously. And of course, rules they had no reservations about. In terms of the Conflicts of Interest Board, their opinion was that since the substitute is non-voting and not paid, that there would not be conflict. They also expressed concern about confidential information. So that's what we found out.
I just want to see if there's a motion to allow Mr. Frosch to sit in as a non-voting substitute for the owner representative, Robert Carver.
Can I ask a question first?
Is there a motion?
Here's a yes.
Here's a motion.
Well, can we answer your question first or no?
Is this, we just need to...
On the motion?
Is there a question on the motion?
Yeah.
Oh, I'm sorry.
Well, I mean, it's relevant to the motion, but
Okay.
are you allowed to answer?
We're trying to get just a motion to see if we're going to allow Mr. Frosch to sit in and a second. If then if we don't, we have a motion on the board?
Yeah, motion.
Oh, Mr. Hernandez is motion. Is there a second? So there's no second. So this motion is not forwarded. Discussion. Do you still want to discuss?
I was just wondering how long Mr. Carter's going to be absent.
Well, I think we discussed it the last time that Mr. Carver had expressed that he may be out for a few months, which would be the summer. But that is something that beyond our real.
There's no updates, I guess.
There is no updates. Do you have an update?
No.
Okay. So without a motion, this thing is not moving forward, correct? Okay.
We need a motion to...
No, there's no motion. We now turn to vote on the minutes from the March 21st, 2019 public meeting. At the board's request, staff added conclusions for the master cases to these minutes. Are there any corrections and comments to these minutes?
Just once again, I would like to commend the board for the minutes as they've been written up over the past year or more. It takes some time to read them, but they're very thorough and they're very well written. And it's a big change from some years ago when you really wouldn't know what happened at a Loft Board meeting based on reading the minutes. So I think everybody should be appreciative of that, regardless of whether they're owners or tenants or the public.
Thank you. My kudos to the staff also. Very good. Ms. Rivera? Oh, we didn't have a motion. I thought that was your motion. I move! Sorry. Is there a second? To accept the minutes, yes. Start. Ms. Rivera, please pull the vote.
Mr. Welch?
Yes.
Mr. Hernandez?
Abstain.
Delaney,
Yes.
Ms. Torres,
Yes.
Ms. Grossman,
Yes?
Chairperson Johnson.
Yes.
5 in favor, 1 abstain, 3 absent.
Thank you.
Related to the meeting minutes
Yeah.
on March 21st, I just wanted to add, that was the session where I asked that the Loft Board staff research the idea of professional certification, self-certification on Loft law buildings, and I just want to explain that I did send an official letter to you
Yes.
Yes.
early this morning.
All right.
Late last night, whatever. So it's officially in writing as well.
Sure. Thank you. We just haven't had a chance to do anything on it. We now turn to a vote of the May 16th, 2019 minutes. Are there any questions or corrections to those minutes? Are there any motion then to accept these minutes? Mr. Delaney, is there a second?
Yeah.
Mr. Torres. Ms. Rivera, could you please poll the board members?
Mr. Roach,
Yes.
Mr. Hernandez,
Yes.
Mr. Delaney,
Yes.
Ms. Torres,
Yes.
Ms. Grossman,
Yes?
Chairperson Johnson.
Yes.
6 in favor, 1 absent.
Thank you. Ms. Paulson will now present her report.
So obviously, the big news of the month is that both houses of the legislature passed amendments to the Loft Law. We're very excited about that. The bill is on the governor's desk awaiting his signature. Last month, at the request of one of the board members, I listed all of the changes to the bill, but I missed actually one very important one, which is that owners of and residents that are in the non-M3 portions of the North Brooklyn Industrial Business Zone will only have 9 months from the date the Loft Board adopts all the rules necessary to implement the amendments in which to file their registration or coverage applications. That's the only statute of limitations type language that's actually contained in the new law. I don't know that I need to go through all of the other changes since I already did that last month, unless anybody has a question about that. Okay, in terms of staffing, Celia Lavelle left the Law Board at the beginning of June. We now have 2 openings for attorneys, and we're doing our best to tread water while we try to fill those vacancies. I'd like to introduce our 2 interns, our summer interns, Michael Chichura, who attends Rutgers Law School, and Jordan Cohn, who attends Hofstra. And thankfully, they have both hit the ground running and are diligently working on various tasks, including less complex cases. In terms of revenue, last month, the board unofficially collected $9,628.50. The fiscal year 2020 registrations were mailed out in early June. In litigation, we have 2 new cases. The first is 383 9th LLC versus New York City Loft Board. The owner is challenging a Loft Board order which denied an abandonment application. The board found that the owner had failed to prove there was no claim for succession rights, and that is one of the elements required for a finding of abandonment. And in 475 Kent Owner LLC versus Pomeroy et al., and the Loft Board is the last in a long line of people named in the lawsuit. The owner is asking the court to enforce a settlement agreement entered into between the owner and the tenant association. The owner amended its plans to require the decommissioning and removal of all the gas lines and the installation of a new gas riser to supply gas fixtures to the roof, such as a fire pit, as well as an electric HVAC system to provide heat, hot water, and electric cooking stoves. The tenants objected and filed an alternate plan, claiming that the existing gas lines in the building could be legalized. The owner claims the agreement bars the tenants from commenting on amended plans or filing an alternate plan unless the amended plans involve layout changes to the units. The owner is asking the court for damages, for an injunction barring the tenants from interfering with owner's legalization unless they own the building, and ordering the tenants to provide access so owner can measure for new windows, and for an order annulling the Loft Board's decision to reject the member's waiver of the amended narrative statement. We went to court last Friday, and the judge declined to sign the request for a temporary restraining order, and there is a hearing scheduled on the injunction for, I believe, the end of next week. That's it.
Question? What damages were they?
They're saying that it's holding up construction, and I think they were asking for like $1.5 million in damages. Not from us.
From the town.
Yeah.
Any questions? Yeah.
Yeah, with regard to that last point, I'd like to request copies of those two lawsuits.
Sure.
Um,
Yeah, I'll circulate it to everybody.
Also, last month, I asked a question, and I have been bombarding you with emails requesting things, so I didn't follow up with this one via email, with regard to whether or not that excellent memo on retroactivity that was prepared last summer by one of the interns from last summer was a public document. And you were going to look into it.
I mean, hold on a second. I think we can distribute it. I mean, it's really just a report on cases, so.
Okay, so it is a public document.
Yeah, I guess so.
Yeah, okay.
Yeah.
That is the best
Yes,
legal answer
yes.
we can give, right? Either it is or it isn't.
Yes,
I
I'm
guess.
saying yes.
Okay, got it, okay.
Also, last month, we tabled the legalization case at 40 West 28th Street that I see did not come back on this month's agenda, just asking for a progress report.
So the board had expressed some concern about the numbers used for the square footage of the, for the equation, for the public comment, whatever. So we had reached out to the owners, the current owners, the owner that did the application, but we reached out to the current owners to ask them for more information on the square footage. And for whatever reason, that letter did not get to them in a timely fashion, and they asked for more time. So that's why.
Great, thank you. And my last question, perhaps 6 months ago, 9 months ago, we had a slight refinement in the interpretation of how many votes are needed to advance an order or an action by the board. And I'm just wondering if you could, I tried looking for it in the minutes and I couldn't find it. I'm wondering if you could just restate that.
So you need the majority of, this is state law, you need a majority of the members on the board. One of the funny things about the Loft board is that it can have a shifting number of members, but since we are now a full board and there are 9 members, you would need 5 votes to move forward. So you need 5 votes in favor of anything to move anything forward, even if 3 people are not here.
Right. But wasn't there a twist with regard to if all 3 special members are present, special interest members are present?
I think the law department was concerned about the special interest member positions being filled, which they are now.
Right.
So I don't know what would happen if they weren't all filled, because when I asked the question, they were all filled.
Right. Right.
So
Regardless, 5 votes are required.
5, yeah. Mhm.
Thank you.
5, but it would have been, say, for example, just 2.
Well, at the time that the question came up, we had 7.
Right, and then the 2 vacancies were not filled. I mean, there was no one, it's not like they weren't present, there just was not filled. The board consisted of 7 people.
Right, but one of the things that the law department was concerned about was that the 3 special interest members of the 7, those were all filled. So I don't know what the answer would be if,
Could we try to find that out?
yeah, we could.
So I'm sorry to drag this out,
Yeah.
but procedure is always trumps content sometimes. If there were, say, 2 vacant public member seats,
Right,
So
well, I
the-
don't know the answer, right?
but all special interest members were present, would a vote of would 4 votes advance them?
Yes.
And that,
And it doesn't matter if they're present, it's that they are on the board,
right,
right? So if there's 2 vacant public member seats, then it's a board of 7, all the special interests are represented. You need 4 to move something forward.
so even though the mayor's executive order says it's a board of 9 members, if 2 seats are empty,
Up to 9.
The mayor's executive order says 5 to 9 members.
I think, okay. I know the state law is vague on how many.
No, the state law says 4 to 9, and the mayor's executive order says 5 to 9.
5 to 9, okay.
Oh, I thought that was a typo. 4 to 9?
I don't know, but it says 5.
Thank you.
Any other questions for Ms. Baldwin? Thank you, Ms. Baldwin. Good job, by the way. There are 7 cases on our summer calendar today. One of those cases, number 6, tenants of 255 18th Street, docket number TM0091 is being tabled. So there are 6 cases on the summer calendar today. First case, Heike Aho and KT Hurton at 473 through 493 Kent Avenue, Brooklyn, docket number PO0073 and TA0243. The second, Catherine Hartling and Jason Miller, 151 Kent Avenue, Brooklyn, PO0084. Ricardo Fernandez, 255 McGibbon Street in Brooklyn, PO0085. Michelle Saberfan at 54 Knickerbocker Avenue in Brooklyn, PO0087 and TA0252. Veronica Schwartz, Pablo Castro, and Julian Asfor, 401 White Avenue, aka 62 South 6th Street in Brooklyn, docket number TA0247. And lastly, Eric Gould, 43 through 49 Bleecker Street in Manhattan, TR1326. Is there a motion to accept these cases? Mr. Hernandez, is there a second?
Second.
Mr. Roche. Ms. Rivera, could you, excuse me, is there any
A discussion on
comments? Yeah.
the motion. So, one, as we discussed in private session,
You can only say what you said in private session, not what other people said.
as I said in public session, it's true, I was the one who brought it up, that a few of the orders where we don't have, where the stipulated settlements are vague or unclear or not privy, we are not privy to, that I do not agree with all of the proposed orders excepting a withdrawal of the applicant's application in certain circumstances. So if we're voting on all of these as a group, I think that's problematic.
Well, you can request to separate out and we vote it separately if you wish.
Even though there's a motion on the floor?
We withdraw the motion? Someone will withdraw the motion? Mr. Hernandez is withdrawing his motion. So could you, yeah. So could you just tell me which one you'd like to vote on separately?
Case 2, 15110. Case 3, McKinney Street. McKinney Street. About 4. No, we have the settlement. Okay, I'm going to say those 2.
So you want 2 and 3 to be voted on separately?
Yes, please.
Okay. So let's just do this again, just for the record. There are 6 cases on this summer calendar. Case number 2 and 3, no, excuse me, case number 6, as was on the calendar, is being tabled. So of the 6 cases, 2 and 3 will be voted on separately. So I'll read the ones now that are being voted on. They are Heike Aho and Katie Hertlin at 473 through 493 Kent Avenue, Brooklyn, docket number PO0073 and TA0243. Then Michelle Zobafian at 54 Knickerbocker Avenue, Brooklyn, docket number PO0087 and TA0252. Then Veronica Schwartz, Pablo Castro, and Julian Asfor, 401 White Avenue, aka 62 South 6th Street in Brooklyn, TA0247. And Eric Gould, 43 through 49 Bleecker Street in Manhattan, docket number TR1326. Is there a motion on these cases? Mr. Hernandez and Mr. Rush. Any discussion on these cases? Any comments?
Yes. Considerable discussion was spent in the private session on the question of some of the 28612 sales that are part of the reason that these cases are on the summary calendar. And given the limited number of board members we have present, even though some of the ones we're voting on now, my general policy is to not vote in favor of a case where the 28612 documents look suspicious or where the terms of the agreement have been redacted. I do plan to vote yes on these simply to clear these cases off the agenda. But I was very heartened that there was considerable sentiment expressed by board members to continue to look at the issue both of withdrawing, to look at the issue of 28612 sales being more explicit, because we had one on this docket for $10 and another one for $20 that don't pass the test. And in addition to take a look at whether there are ways that we can strengthen that provision so that there's no abuse. But I will vote yes on these.
Thank you, Mr. Lane. Any other comments? Ms. Rivera, could you please poll the board members?
Mr. Roach,
Yes.
Mr. Hernandez,
Yes.
Mrs. Delany,
Yes.
Ms. Torres,
Yes.
Ms. Rosenberg,
Yes.
Chairperson Hudson,
Yes.
6 in favor, 3 absent.
Thank you. The next 2 cases are Catherine Hartman and Jaron Miller, 151 Kent Avenue, Brooklyn, docket number PO0084, and Ricardo Fernandez, 255 McGibbon Street in Brooklyn, docket number PO0085. Is there a motion to accept these cases? Mr. Hernandez, thank you. A second?
Awesome.
Thank you. Mr. Rush, is there any discussion on these cases? Any discussion, any questions? Any comments? Ms. Rivera, could you please poll the vote?
Mr. Roach,
Yes.
Mr. Hernandez,
Yes.
Ms. Torres,
Yes.
Ms. Rosenberg,
No.
Ms. Delany,
No.
Chairperson Hudson,
Yes.
4 in favor, 2 against, 3 absent.
These two cases did not pass, right? So they're tabled. There are 6 cases on the master calendar. The first case is Ryan.
Oh, there's still case
There will be 6.
3.
There are 6.
Number 3.
I'm sorry, number 12
Can
would
we
be.
vote on 2 and 3 together?
Oh,
Did you want them separate?
No, that's fine. I just assumed they were going to be separate, but no, because it's the same issue for both.
It's the same
It's the
issue?
same issue for both.
Okay. I assume that you wanted those two voted on separate.
No problem.
Okay. I'll separate them together. All right, there are 6 cases in the master calendar. The first case is Ryan Coonan at 140 Metropolitan Avenue, Brooklyn, docket number PO0078, and our intern, Mr. Chichora, will present this case. Go easy on him, it's his first time.
Good afternoon, everyone. Loft Board members, members of the public. My name is Michael Chichera. I'm one of the legal interns at Loft Board this summer. In Loft Board Order 4333, the Loft Board granted an application for coverage to the building located at 140 Metropolitan Avenue, Brooklyn. The Loft Board also granted protected occupant status to Ryan Coonan for the first floor unit. The Loft Board specifically rejected the owner's argument that Ms. Coonan was only the protected occupant of one room in the first floor unit. Owner appealed the board's order pursuant to Article 78 of the New York Civil Practice Law and Rules in the Supreme Court. On July 12, 2016, the judge dismissed owner's petition and upheld the order. On January 23, 2018, owner filed an IMD registration for the building and stated that Ms. Coonan is the protected occupant of one room in the first floor unit, ignoring the Loft Board's finding in the order and the judge's finding in the Supreme Court. On February 8, 2018, Ryan Coonan filed an application challenging owner's registration. Owner failed to timely answer the application. On January 14, 2019, the Loft Board issued a notice of default to owner, who then filed a motion to vacate the default on February 14, 2019. The proposed order before you today dismisses the application based on the doctrine of res judicata. Ms. Coonan filed an application challenging owner's registration, but in essence, she's asking for another declaration that she is the protected occupant of the whole first floor unit, not just one room. The Loft Board decided this issue in order number 4333. There is no reason to reconsider the decision here. The proposed order also dismisses owner's motion to vacate default as moot, based on the dismissal of the underlying application. Thank you.
Thank you, Mr. Chichora. Could you just stay right there for a second? All right. Is there a motion to accept this case? Okay, Mr. Rouge. Is there a second?
One second.
Mr. Delaney. Is there any comments on this case?
Yeah, I have a comment. This particular behavior on the part of the landlord to file a registration stating that someone's the protected occupant of one room in a unit is troubling to me, and I gather this is that it was not necessary, plus we're dismissing it as based on res judicata, for Ms. Coonan to have to bring this application, and that in our view, she is the sole recognized protected occupant of the entire first floor unit, or what is it, the first floor? Yeah, first floor unit, of this particular inter-multiple dwelling. Therefore, it appears that she spent money having an attorney file this without need, but I certainly understand why one would be troubled to have that filed this way. So I would, I plan to vote yes. I seconded the motion, but I would ask that the Loft Board look into ways to try to curb this kind of behavior on the part of owners in the future. Years ago, in the very early days of the Loft law, we found a building right here in Tribeca that had 13 covered units, 6 on one floor, 7 on the other floor. But out of pure spite, the owner filed registration stating that there was one unit on one floor and the other 12 units were on one of the other floors, just to be, I guess to use the common term, a yelts. But it seems to me that if there's a way we could, in the future, prevent this kind of unnecessary.
I have a question. Is there, enforcement-wise, is there such a thing as filing some, like the board orders a particular building to be registered a certain way, and they register, and they do not register it a certain way? Is there anything we can do for?
So one of the things that we're proposing in the rule changes, which the board hasn't gotten to yet because it's at the end of the rules, is to have a violation of a Loft board order and have a penalty for that. So I think that this scenario would fit in where the board ordered the owner to register the unit as his own, but the owner didn't do that. So obviously we have to do that on a case-by-case basis, but I think that's one way to handle the situation. And it is something that we have talked about. The board has talked about it, but we haven't gotten there yet.
Is there something that can be like corporate, like filing a false registration?
Yeah, well, one of the things.
Not just violating your.
Oh, well, I mean, we did make a proposal for filing false documentation, so that was something else that the board had discussed. But again, we haven't gotten to the penalty part of it yet, so I don't, whether or not this would be considered false, I don't know. But yeah.
Okay.
Well, I would say it's false, and I would say this is part of a larger discussion of different filing procedures and documents that we've been having about, DOB. It's no different than if you falsify a DOB application and you say you're going to need 2 bathrooms instead of 3 or something, you can't. It either is or isn't. You can't put down the wrong address, you can't put down the wrong unit number, there's certain requirements for filling out all forms properly, and so
So we just have to craft, or when we get to that piece, those penalty piece, to craft a specific violation for that kind of stuff. That'd be great. Thank you, Ms. Paul. Thank you. Ms. Rivera, could you please poll the board members?
Mr. Roach?
Yes.
Mr. Hernandez?
Yes.
Mr. Delaney?
Yes.
Ms. Torres?
Yes.
Ms. Grossman?
I recuse myself.
Ms. Shepherd? Chairperson Hunter?
Yes.
6 in favor, 1 recused, 2 absent.
Thank you, Ms. Rivera.
5 in favor, sorry, 1 recused, 0.
All right, very good. Thank you, Ms. Rivera. The rest of the cases on the master calendar are removal applications. We are tabling number 12. Now the rest of these cases are voted on as a group. Alpha Big Foods Inc., 160 Franklin Street in New York, Manhattan, LE 0640, and Miracle and Realty Corp., 197 Henry Street in Manhattan, docket number LE 0700. Then Talmud Torah Denitra, 178 Walworth Street in Brooklyn, LE 0704. And finally, 354T LLC, care of Ion Site Sita, 352 Troutman Street in Brooklyn, docket numbers LE 0706 and RG 0205. Is there a motion to accept these?
Can I say something first? Or no?
On this case, could we, okay. I prefer the motion first.
Oh, motion and then a discussion?
Yes.
Okay, fine.
Is there a motion to accept these cases?
Possible for me to sit up closer?
I make a motion.
Yes, Ms. Grossman. Second, Mr. Rush.
Oh, I can say. Oh, I just wanted to ask the law board staff to look into, well, I wasn't privy to the information, but I wanted to make sure that when a unit is emptied and there's plumbing, kitchen and bathrooms removed, I just want to make sure that it's done the proper way with the Department of Buildings, Schedule B.
Right. And I would even add to that all work should be done.
All work should be done but
Right.
probably, so I just want to, something about the wording made me question on 2 of those cases, the filing. I'm not allowed to look up anything, so I didn't, but I would like the law staff to look into it and then let me know.
Sure. Can I amend my motion to be that we accept these cases with the caveat that moving forward, we would,
Well, that could be a separate request. You could make a motion after, but she just made it. But make it into a motion.
Okay.
What you just said, you could just make it a motion, but after.
After.
business.
Yeah.
Okay.
Okay, yes.
Yeah, I would also comment for the public's behalf that of these 4 cases that are on the removal calendar, one of them is a building where the tenants are in place and the order sets rents in 5 units. Considerable discussion was held in the private session with regard to the other 3 buildings where the owner of each is returning them to commercial use. Well, 2 of them are returning to commercial use. And that's where I think we want to take a closer look at making sure how the work is done. So I plan to vote in favor of these.
Sure, I just comment-wise, the distinction between return to commercial versus residential, were you trying to make a distinction there?
No, just that since we don't give summaries of the removal cases, I think just for the public so they understand the concerns that have been expressed by my colleagues, that, and we are seeing the odd phenomenon, maybe not odd, but neighborhoods around New York City where commercial uses are becoming competitive with residential rents, particularly in kind of gig economy, WeWork style buildings, and it's an interesting phenomenon and one we need to keep an eye on.
Right, I think partially the point would be that when a building goes through the residential conversion process, part of that process is obtaining a residential certificate of occupancy of the residential portion. Right, so the work that's done under our jurisdiction is kept track of, whereas the work that is done under a building that's reverting to manufacturing use seems to be not, right, so there's less eyes on that. That's the point of the discussion.
I think also for the public to know, just out of these 4 cases, one leaving with the proper residential CVO has zero loft law tenants.
Zero,
It's all
rent
market-
regulated.
Rent regulated, it's all market rate because of how things played out. 2 are going back to commercial and 1 has 5 rent regulated. Just to keep track.
Thank you. Are there any other comments? Mr. Rivera, can you please pull the board members?
Mr. Roach?
Yes.
Mr. Hernandez?
Yes.
Mrs. Delaney?
Yes.
Ms. Torres?
Yes.
Ms. Rosen?
Yes.
Chairperson Wilson?
Yes.
6 in favor, 3 absent.
Thank you, Mr. Rivera. If the public could just be patient with us for a 2-minute break, and then we'll go into rules. Oh, I'm sorry, there is a motion. I'm sorry, go ahead. There's a motion on the floor. I think, Mr. Rosen, you have that.
Oh, I thought you was making it. So the motion, I make a motion to include DOB filing records applications for removal of illegal work in the cases of.
I'm sorry, you're asking that DOB records be a part of the removal records?
Yes.
The backup material.
For,
I-
this face.
I
All right, Martha doesn't.
Martha's going to listen to
Reword
you
that.
and craft.
That
Okay, so let me just rephrase it, this is what I think, and then you tell me if I got it right. You're making a motion to have the apartment buildings inspection records and records, permit records, job records filings, and inspection records in removal cases be a part of the Loft Board's record.
Only for
removal.
manufacturing.
Oh, for by C units.
For units where they're no longer going to be residential?
Correct.
Okay, so that's my question that I had to Chuck. Why not have it just in all cases? Because across the board.
Where it's not in compliance with the stated certificate.
You want to make sure what you're trying to do is to make sure that buildings are converted or not remanded, but going backwards legally, correct? And it's done properly. Is that what you're trying to assert?
Yes.
Right. So did I say that right? Okay.
Sure.
Could you say that again?
So in cases where work is done contrary to the certificate of occupancy, that remediation work, proof of Department of Building filings are presented as part of the backup documentation.
And inspections.
That would be part of it,
I
yes.
thought that was, no. A filing of a permit does not make it legal, right? Okay.
No, it would, I mean, if you, so.
Well, no, I mean, you can always file the job and not do the work, right? So you understand? So that's why.
That's true, so you would need a plumbing
You
inspection.
need
plumbing
the
sign-off.
apartment buildings records in its entirety, basically.
Yes, yes.
All right, we'll spare you on that, I'm saying that again. Are we good? On the motion?
This is all buildings.
Yeah, all
buildings that are removable.
the removal.
For every building? Oh, but only where they're
Removed
by C,
by
right?
C and
Commercial, right? Are they going to be commercial units?
Well, yeah, because that was definitely a scenario. It's a commercial
Yeah.
manufacturing, so where there's where you're trying to rectify or remediate in order to be in compliance with the stated certificate of occupancy. That's what I was saying.
Okay, so
Right, work
we'll-
done to bring the building in compliance, that's a great way to say it. Work
Yeah.
done to bring the building in compliance with the certificate of occupancy
Yeah.
we want to see the records.
as part of the record, as part of the Loft Board records. Yes, okay.
I'll second.
Look at that, Mr. Rush has seconded that motion. Any discussion on those? Mr. Rivera, please report the board member.
Mr. Roach?
Yes.
Mr. Hernandez?
Yes.
Mr. Delaney?
Yes.
Ms. Torres?
Yes.
Ms. Roseman?
Yes.
Jefferson Nelson?
Yes.
6 in favor, 3 absent.
Thank you. Ladies and gentlemen, just have a 2-minute break, then we're going to go, Boston will lead to the rules discussion. The record. Ms. Boston?
Okay, so we're going to continue with our discussion with 209. It's been such a long time, I'm not 100% sure where we had left off, but I know one of the open issues was if a protected occupant is proving primary residence, if somebody wants to be a protected occupant, what is the time frame that they would have to prove primary residence? And we talked about from the date the application is filed, and if there's a trial, through the date the record closes. So I believe Mr. Carver wanted something more extensive, and that's sort of where we left it, and I don't know that the board ever came to a conclusion on that. So that is the proposal. If somebody has another proposal, let's talk about it.
Can you say that one more time?
Sure. We had talked about if somebody who wants to be a protected occupant, it's 4, number 4, 209B4.
Right, just repeat what the period.
Right,
would be.
so the period that I wrote down here, which, you know, it's a draft, it was just for discussion, is from the date the application is filed, so you're filing an application for a protected occupancy, you should be residing there as your primary residence, And if there's a trial through the date the record closes. So we felt that was, oh, but then, I'm sorry, but we had also talked about, it might be hard to figure out when the record closes if somebody had testified prior, whether or not they're still using the unit as a primary residence. So we had also talked about through the last date that they testified.
And then I said, we should make it clear that they have to show up to testify. Oh, sorry. Show up to testify. I think I used the example of a school teacher, like my husband who didn't show up to testify, but went through isn't that the issue we were saying? Because you have to be present at oath. You're allowed to have a lawyer represent you, but what you're suggesting is that the tenant actually has to be physically present at oath in order to close the...
I think that's it's an interesting issue. I think it could be someone, I mean, usually the proof that comes in for coverage is you have a multitude of people that are testifying as to residential occupancy during the window period. But if it was just protected occupancy, I would think that it would have to be the tenant or somebody with firsthand knowledge. So let's say, for example, it was a husband and wife, right? Or spouses, let's use spouses, because it doesn't have to be husband and wife, right? So I think one spouse could testify that both live there and both are entitled to protection. I don't know that both of them would have to come in. Do you know what I'm saying? But I think that there has to be some proof and some testimony by somebody with firsthand knowledge.
So not a lawyer can't.
No, the lawyers can't testify.
Okay.
If they're going to testify, then they can't be the lawyer. Yeah, whether or not they try is a different issue.
How does this relate to then what the time period?
I think we're trying to, a lot of times the time period ends up becoming gigantic, that you have to, the amount of evidence over time, right? A case
Well,
at
it
the tail end.
depends on when you file the application. I mean, if you file your application and there's going to be a trial at oath, yeah, it could be a couple of years, but it's certainly less than from the effective date of the law, right? So I think this is a way to limit it, and in terms of the types of proof, if we limit it to the last day of testimony, I guess a better way to say it would be about the tenant's primary residency in that unit. That would be a way to limit it. Because if you go to, again, if you go until the day the record closes, there could be a gap, let's say of a year, right, from the day that one tenant testified until the day the record closes, particularly if there are multiple people filing an application together, which does happen.
Was there a difference between, or there is a difference between having to continually provide proof and being able to prove? And so as part of the application, you provide documentation of primary residence, right?
Well, I don't know that we necessarily want to take all of that in as part of the application. Normally what happens is they file it during the trial.
During the trial. And so the way we've been talking about it or thinking about it is that the objection is that one needs to continually provide documentation proving residency up through the whole process. But couldn't it be stated that you don't have to keep giving documents, but if it's contested at some point for a valid reason, you would have to prove or provide proof? Like, so some, you have to, one has to have proof of primary residence to be provided during any time during that period.
If we change this rule to say this, then the burden will be on the person that's claiming protected occupancy, right? So it's your case, you're bringing the application, you need to prove your case, and part of proving that case will be primary residence during a period of time.
Correct, and we're
So-
trying to make it unnecessarily burdensome, so
We're trying
we're
to,
trying not to make it unnecessarily.
yes, thank you.
While, but, so, right.
Can you maybe describe anecdotally, someone at the tail end of 2010 Loft Law, the amount potentially of the burden of their proof that they would need to?
So if they filed their application on June 15th, 2017, which would be the last date that you could have filed an application, right? And that application went to oath. I mean, obviously this rule wasn't in effect, so it wouldn't matter, but let's assume the rule had been in effect, and it went to oath, and they testified in oath. The last day they testified in oath was December 15th, 2018, then they would have to prove primary residence from the date they filed the application, June 15th, 2017, through the last date they testified, which would be December 18th, 2018. Right, so you're talking a year and a half. Now, if somebody had filed their application for protected occupancy 2 years prior, in June of 2015, right? And for whatever reason, that case was delayed and didn't get to be heard at oath until December of 2018, then you're talking 3 years, right? Or 2.5 years.
Plus the 2008, 2009 consecutive 12 months.
No, we're just talking protected occupancy. We're assuming it's covered.
Covered. Okay, all right, just.
Now, if the coverage application is tied to the protected occupancy application where they're being heard together,
Yeah.
then yes, somebody who's claiming coverage under 281.5 is going to have to prove window period occupancy.
Right, so they would have had 12 months consecutive either in 2008, 2009, plus June 10th, 2010, June 21st, 2010, that day.
Right.
Now, you mean if they the law?
Yeah,
Doesn't necessarily include the same person.
Right.
oh, someone,
Can you say that a little louder?
Doesn't necessarily have to be the same person. It could be one person there during the window period, one there on the law, and then you meet them 2 years later.
but someone else, they have,
Someone had.
someone has
Someone
to,
had to be there for coverage
Right.
for those 12 consecutive months.
so, okay. And hypothetically, if it takes 2 years to get to oath, does it? Do we know the wait time?
No.
No. I mean, oath works on its own timeframe. We have no control over their calendar.
But to get to oath.
To get to oath doesn't take a long time. How fast it goes once it's at oath is different. It's going to be different for every case depending on the number of parties involved, what their schedules, what the ALJs are up to in terms of, because they have multiple agencies that are feeding in. It's
Yeah.
not just us.
I think on this point, my first question is, what are we trying to protect against here? If we were to adopt this provision as it's currently proposed, the beginning point would be the date the individual applies for either coverage or protection or both. And as you know, the tenant position has been consistently that all this is unnecessary, that the owner should register the unit, list the occupant, and then if there's a primary residence issue, take the occupant to court. And I just want to restate, that's still my position. But if you look at this, okay, we're saying you're now going to be able to be questioned as to whether this was your primary residence on the date you filed the application. And we're not just going to accept that one day, we want some other day over some period of time. What are we trying to accomplish?
We want to make sure that people who filed applications are still there and don't leave.
On the theory that if I leave,
Why should you be protected under the law if you're not there?
Could you explain?
Assuming that you're not there for all of the reasons that the board has already said are okay, like you're in the military, you're teaching in Detroit or whatever, right? Other than you're away at school, other than those kinds of aways, right? We've had instances where people filed for protected occupancy and then they left the unit and they still wanted to be protected, and they shouldn't be protected, in my opinion, because that's not what the law's about. The law's about protecting people that are there. That's what it's for.
and as we discussed, this question of till the time the record is closed has some problems.
Right.
And I'm just, again, it seems to me that what we're trying to guard against, and I don't know if there's any way to guard against it in this particular rule personally, is I guess some kind of abuse that it was my primary residence, but now it's not my primary residence, and I'm a protected occupant, and I'm going to rent out my space for a profit or turn it into an Airbnb. I mean, what are we trying to...
I don't even care whether or not they're renting out a space for a profit or Airbnb. I care about, the law is about making these spaces safe for people that live there. And if you're not living there, you shouldn't be protected under the law. So, regardless of the fact that you're renting it out for, I don't approve, please don't get me wrong, I do not approve of rent gouging or any of those things.
Right,
but,
I'm not
if the purpose of the law is to say, we want these spaces legalized and safe for the people that are living there, and these people should be protected, then the people should be living there. That's what the law was about. That was always what it was intended to do.
Okay. Can I ask a question again? My hypothetical June 15th, 2017 person.
Right.
If we did not amend the law to read as you're suggesting, what would they experience?
It would depend, I think, on whether or not they're the prime lessee, right? Because the prime lessee, the board has held that if they're the prime lessee, then they have to prove primary residence, but if they're not, and there is no prime lessee claiming protected occupancy, they would just have to prove residential occupancy, which is not necessarily the same thing, I don't know. So the current rule says, right, a residential occupant is entitled to protection, that's what it says.
So, if we adopted it that the requirement is that it's your primary residence on the day you apply for coverage.
For protected occupancy.
For protected occupancy and possibly also coverage.
Yeah.
And it is, and you are able to demonstrate that when we adopt the language that the date of the record closes. So Chuck was there when he filed, he used it as primary residence, was there on the date the record closed, used it as primary residence, gets listed as a protected occupant, then decides to stop using it as my primary residence and go spend the majority of my time with my supermodel wife who lives in Los Angeles, just hypothetically. Then now I'm a protected occupant, and the owner's still going to have to bring a case against me in housing court.
Yeah.
Right?
Yeah.
So again, it's not clear to me, and even if I then continue to come back to New York every now and then and stay in a unit for which I am named a protected occupant, although I'm sneakily no longer a primary resident, I think we're just as concerned about my health and safety then. It's not like we're concerned about the health and safety of primary people who were supposed to be there. We're concerned about the health and safety of anybody who's there.
Anybody's there, right?
Right, so I still don't understand. There's a natural mechanism to get rid of people if the owner believes it's not their primary residence. There's a natural mechanism to get rid of them in housing court. I still don't understand what we're trying to do here.
Yeah, I think that's interesting, and I'm just speaking off the cuff, but I guess I was misunderstanding. I thought this was set in place to put an end date, because if you happen to have lawyers that are being very aggressive with each other, they might really make someone just like do binders and binders of proof for years.
Yes, that was definitely a concern.
And that's happening now.
that we're trying to put an end date so that there's not endless, like there's not a factory filled with binders of one tenant's attempt to get protection. I thought that was what we were doing here, but we're actually that would address that. But for all the other people that don't have aggressive lawyers and they're working more in working better with their landlord and tenant issues, then are we putting more burden on those guys by doing this?
I'm not sure. I mean, it would depend on how it would play out. One of the problems with the Loft law is that there's no generalities. Every case is really unique. So would there be times where people would be more burdened than they would now? Probably. I'm not going to say no. Is it worth it to make sure that we're protecting the right people? I think so. I mean, if you don't, again, it's your rule, but I was very concerned about the cases that we've had where people filed these applications and then they just weren't there and they thought it was okay for them to be protected anyway. Like how can you in good conscience say, well, we know that person's not there and we're going to protect him anyway? I don't see how we could do that. That just goes against a whole lot of what I believe in.
So what do you propose?
So I think we should require for them to be protected. It should be their primary residence, and that they should have to prove that. And that the period of time, my proposal at this point, which is not actually what it says here because we have moved on to other things, is from the date that they file the application, right? They should be living there on the date they file the application. You don't get to file the application and then move in, because that's not what the law's about. And, just in terms of administratively, it makes more sense to say until the date that they finish testifying or whatever proof is being offered about their residency, whatever date that is. If there's a trial, obviously if there's no trial and the owner is just registering them, then they don't have to worry about it. And the owners, sometimes there are owners, the owners will agree, yes, they were there, and if the unit is covered, then they would be the protected occupant. I mean, there are owners, that does happen.
So it would be
From the date of the application until the date that I'm trying to think of a way to phrase it. I mean, the best way to say it is until the date the testimony about that unit or the occupancy of that unit ends, whatever date that is at the trial.
Until the date the occupancy unit is assigned.
Well, no, because then you're going past the date the record closes, right? So in other words, let's say the trial starts on January 1, and there's 3 different units at issue, right? Three different people claiming protection of different units, right? So person 1 testifies in February, person 2 testifies in March, person 3 testifies in April, right? So person 3 is getting a raw deal because they have to prove a longer period, but you have to do something. But person 1 would only have to prove from the date they filed the application until the date the testimony about their occupancy ends. So that will either be them testifying or somebody else testifying about their occupancy
But
to address Mr. Moskowitz' point, which was is a good point.
But regardless of what we do, if we say that the area in which, if the landlord's attorney chooses to, the landlord's attorney can torture you is 12 months, but for you, Unit 4, it's 16 months, and for you, Unit 7A, it's 22 months. But whatever it is, we've got 2 points that I remember from geometry that determines a line, right?
Right.
But the minute that line ends, the next day I can stop using it as my primary residence.
That is true.
So we're going to this, so maybe we don't need a line. Maybe all we need is a point. If you go this route and say, okay, it's got to be a primary residence on the day the application is filed, then if you prevail, you're a protected occupant. And somewhere down the line, if you're not a protected occupant, it's not as if by passing this rule that I don't think we need, but if we pass it, we're not taking away the owner's right to go to housing court and seek an eviction based on non-primary residence. So, you know, my argument has been all along that we're creating very harsh medicine to treat what I don't think is a problem that doesn't have a more natural way to be addressed.
Except isn't part of the testimony part of the proof of primary residence? Like you testify that you live there, that's...
Or you testify that you don't live there, which is what we had. Right? I mean, we had people that got on the stand and said, yes, I was there on the application date, but then I moved in with my girlfriend and I'm not there anymore. My cat lives there, but I'm not there, but you protect me anyway. How do you reconcile that?
And that case is currently under an Article 78, if I recall.
No.
No?
Oh, is it?
Yeah, I think it is.
Oh, that part, there have been so many different, there was a lot of people there and there were different pieces. That one may still be pending.
Right, and again, you know, we're speaking about the importance of the board adopting a rule, but the whole bifurcation, I'm trying to work in asymptotic today. I haven't figured out the whole bifurcation of, it used to be you applied and it was for coverage and protected occupancy together. That whole fork in the road was created by a prior executive director and prior staff without any loft board discussion, without any public hearing, without any rule. And so, you know,
So let's fix it.
I don't know. I think the question is first to find out what it is we're trying to fix, because I'm still not persuaded of that. If we set up a rule where tenant one has to demonstrate a line that's 12 months long and somebody else is 16 months long and whatever, but the minute, however long that line is, the minute it's over, I can like do something else. What abuse are we protecting ourselves from here? Why not just stick to that point?
I think that's, I actually like your analogy, because it's like that person who's going to cross the line is going to cross the line or the point no matter where, probably no matter where it is, because that's that type of bad egg. But the majority of people aren't doing that, and there is another means to catch that bad egg in a different court. So
But you're putting a burden on somebody, and just because Mr. Carver's not here, okay? But you're putting a burden on an owner to have to go to court to evict somebody who doesn't live there, when we all know they don't live there and shouldn't be protected to begin with. I don't know, that seems, there's something wrong with that.
I don't know statistically, but like if I speak kind of from personal experience, we had a kind of a nice, everyone gets along. So the thought of myself having to go through another 18 months or something of proof, that when I already provided a binder of other proof, I don't feel like I should be unjustly have more information to prove, because we were functioning fine through our
You're saying
experience.
about your specific case?
Well, I mean, I speak because I've been through this. I've been through this recently, so I know what it entails, and I don't want to make it more complicated because it's already, I thought we were trying to make things easier for people, not for them to cheat, but just for them to survive, both sides, with lawyer fees. And so I don't want to add in a parameter, as Chuck is describing, that might be a string for 12 months or 18 months or 2 years, that is an extra amount of lawyer fees for both sides to deal with this, that they wouldn't have had to before.
How much more burden are we saying about enacting these? Like the way you're suggesting it, how much more of a burden is it? Because I think if we have some protections in place, I mean, depending on the burdens, maybe the qualification in order to recertify, which I don't think is that much of a burden. You know, you're just saying, make it simple enough just for you to recertify, allows for the owner and the tenant to be in a place where at least you're justifying people who should be in that type of housing. Because the key also is making sure, to your point, make sure that the people who deserve to be there are there. And while we may not think the number of bad apples are like substantial, enough is out there to like, you know, I guess corrupt the system at large. And so, I don't know, I'm not sure how much of a burden it is in order to prove this.
I mean, we put in some guidelines, right? In section 6, right? So we put in some of the guidelines, whether they live there, whether they keep their furniture there, whether the unit is listed as in the child's school records, whether the person listed the unit as their address on official documents filed with government agencies. I mean, these are the guidelines that we put in. I know one of the complaints that we've heard is that it creates sort of these rolling discovery deadlines, and so people have to keep supplying things the longer it goes on. And I don't know, I mean, we could limit discovery, but...
Is there a way to set the starting point on the line, but keep the ending point on the line flexible so that off-board staff can, with the board, make that determination of the ending point? Because it seems
Well,
like
you can't go past the date the record closes, right? Because that's the world that you have, right? You're making a determination based on what was produced at trial. So we're not going past the date the record closes, regardless.
Right. But there seems to be, I'm sensing there's a little bit of a concern that, kind of like the luck of the draw, like the first person may only have to be 3 months, the second person maybe 6. So is there some way to eliminate that luck of the draw, so to speak, so that it's more a level playing field to...
Well, I mean, everybody could file their own application, but I think that creates a lot of problems, because one of the reasons people file joint applications is so that they can share attorney's fees. So that can create a lot of problems itself. So we could say in a rule, yeah, there's only one applicant per application, but I think that produces a whole other level of hardship that I really do not want to impose on anybody. We should just leave it away.
I think the answer to that is no.
Where the board wants to protect more people,
Right.
right? So I think that's what started this.
Well, I think there were two things. One was to protect more people, and the other was to protect people that are actually there. That I think it was a twofold.
To try to avoid abuse.
Right.
What was it before? I'm sorry. This is...
What is it now?
Yeah, what is it now?
So now, which you actually have, because it's the deleted part at the beginning, right? So, if there's no prime lessee, the occupant qualified for protection is the residential occupant in possession of the unit covered as part of the IMD. And then there's a whole thing about whether or not they were there before or after the effective date of the law. not. And then we have the section about the prime lessee, having to prove, the prime lessee or a sublessor are not in possession, having to prove primary residence. So that's what it is now.
But what it is now, we still have that problem, you said, technical people.
Yeah.
And the first language here is whose, because you mentioned before that you had some language, but that wasn't reflected here.
No. This is still my language, but after the last discussion, we had sort of moved the ending date, right? We discussed the fact that I think everybody was okay with from the date the application is filed, but what the ending date should be was problematic. So the discussion was centering around what the ending date should be. And the reason that it shouldn't be the date the record closes is because if somebody testifies and then the record closes a year later, well, what happened during that year? So, you know, make it in the rule, the date the record closes, then.
So this first piece, only if the individual uses the unit as a primary residence. That's not use or continue to use the unit, then what difference?
And just end it there?
No,
That's kind of
I'm saying because that take care of your concerns, whether or not, in terms of this piece in the right here, from the date the application is filed, and if there is a trial through the date the record closes.
Right.
In previous phrase, take care of that concern about whether or not the person can get protection.
So
and
you would
not-
say to be a protected occupant only if the individual uses and continues to use the unit as a primary residence?
Right, and that takes care of that. That concern about somebody. No?
I can see a lot of litigation coming out of that. What does it mean to continue to use? But yeah,
Maybe we can
it's
define-
better.
Define the phrase continue to use. That's the question.
One date, or, to use the word analogy, one point, or a line. So if we get to the point where if they want two, then we can ask them to go down this road as to where it's the point. But if most of the board members believe it should only be a point, then we can have a discussion about when it's an end.
Okay with that.
So
I haven't saw that. Ms. Cruz, I'm not hearing.
I'm just asking, perhaps I would like to get a sense from the board members whether they believe in Mr. Delaney's point, or if they want a line. Do they want a beginning, the filing date and through the end of the record, or just on the filing date?
And the benefit of having that end date is determined on
That the person has during some period of time, the person is continuing to reside in the unit and using it as a primary residence.
And if we don't put an end, then we just basically granted it and give the person free reign forever. Not forever.
Well, not forever, because as Mr. Delaney says, the owner could always say, if the owner says, well, you're not actually there, the owner could theoretically evict them.
So it's really about the duration of the process of providing protected,
Proof.
right? So
Well, I believe there should be, for the sake of trying.
Let me ask, just for the sake of Ms. Ryan, if you can speak louder.
I believe there has to be some sort of mechanism in place to prevent abuse. Or to have that solid line from point A to point B. I don't know exactly how. So, yeah, so you said you were kind of trying to get a consensus what the board wants. What I would like is for us to have some mechanism in place here that we can prevent what in the past has occurred to be abused.
So if the idea is that the board would want the person applying for protected occupancy to prove primary residence, does that person prove it on the date of the application or on the date of the application through another date? So it's the point versus the line.
If it was the point,
Yes.
don't they move in and then so then they're, let's say they win and they're covered protected occupant, then you, as a protected occupant, you always have to be a primary resident.
Yes.
So you move right into being a primary, like being under obligation to be a primary resident, don't you? I mean,
That's right.
I mean, you can't have a primary residence somewhere else. You have to, there are rules once you're a protected occupant. You have to be a primary
But
resident.
we're
Talking
talking
about
about
is the
who should
period, the
Right.
period
Standard.
before you're a protected occupant.
Right.
So just that little
So it's like-
window,
yes,
that line.
it's like this vague window between when you file your application and when you're protected.
No, what we're asking is on the day you file your application, let's say you filed it on April 15th, this is the next day, right? You filed it on April 15th, and on April 15th, you can show that your child goes to the neighborhood school, you keep most of your belongings there, you show that you
Vote there, you
vote
vote
there,
there,
register, yeah, all of those things, right? And on this day, you have all of this evidence, and you present all of this evidence to show that this is how you use, that this unit is your primary residence. Now, the question is that enough for it to be, for the Loft board to determine that yes, with respect to primary residence, this is your primary residence? Or does the board want not only for you to be able to prove that it was on April 15th your primary residence, but through the date that you go before the oath judge and say, you know, this is, I live here, this is my primary residence, all from that time to that time, which could be some time.
But aren't they just all the same documents, basically? I mean, it's like, okay, my bank I download my bank statement from April, I download my bank
Yes.
statement from December. I
Well,
still have my driver's license,
Mr.
I
Delaney-
still have my school,
Yes.
my kid's school register. Like, there's not a lot of additional stuff that you're, I mean, if you can prove it once, you can prove it a year later.
He makes a good point, though. If you have multiple applicants for multiple units, that could be a different day, and that could be a totally different school year. That could be a totally different registration, car registration year. So it may lead to that person requiring to submit additional information that perhaps someone else that's in the same case does not have to produce. Makes a good point.
Right, so the burden is higher on tenant number 3, who happens to go number 3. Right, tenant number 1 has the easiest ride, tenant number 2 is in the middle, and tenant number 3 has a longer period of time. And it could be a year in between.
But, so the person who goes first could possibly get the benefit, right?
Yeah.
Then the person who goes not.
The one who was first.
We're not going to solve the entire sports problem.
Yeah,
Well,
the one
first
that goes
has to be
first will produce more evidence if it
Because he's
takes.
continuously,
Yeah,
he or
exactly.
she's continuously having to prove.
Oh, yeah.
As opposed.
Well, if there's a second line, right?
Right,
Right.
there's a second
Right.
point, as opposed to, it's just on the filing date. I can show that, you know, I use this for all, you know, and have all of the evidence for that particular day, and that'd be it.
So what you're saying then is if you do the first, if you just prove one point, we're the 3 applicants, you proved it, I come in, I prove mine, you don't have to prove again, because otherwise what we're asking is then if I go in, you're like, oh shoot, now I have to do this all over again.
And God knows, like, I'm sure most landlord attorneys aren't out to just like drive people nuts with excessive document demands, but it does happen. So that, and no matter how long the line is, there is the possibility that right after that,
What is your proposal? What do you say?
my point was, it seems to me that if you want to require a showing of primary residence, if one does it at one point in time, that it's not as if Chuck's declared a protected occupant, it doesn't make me immune from a
primary residence issue down the road, whether it's 3 days later or 30 years later. And to be clear, I've said this before, but I am not trying to protect people who are abusing the system. My college roommate kept his rent-stabilized apartment on the Upper West Side for 20 plus years after he moved out and rented it as a moneymaker. Tenants who abuse and use the landlord's property to profit, whether it's through illegal subletting or through Airbnb, are bad for the tenant movement. They give tenants a bad name, just as certain like really rotten landlords give landlords a bad name. But it's not as if having proved it, whether I prove it for 1 point or over 3 months or over a long period of time, I'm not immune to being brought up in housing court for not using as my primary residence on the 4th month or on the 40th year. So I don't think we need to go through such an elaborate exercise to prevent an abuse that A, we can't prevent, and B, for which there's another mechanism to cure.
So where's Mr. Carver's position now? Like, just kind of going, like, what was the landlord, I mean, because we don't have representation today. So what was the position that he was arguing for? I'm just trying to remember.
I remember he was going to talk to some lawyers, he said.
Right,
But I don't, if he never turned anything in.
In the interest of fairness, I think I can summarize some of his points, which is why make the owner go to another venue to raise a protected occupant claim that it's inefficient. And obviously, our primary residence claim. Obviously, you know, my former roommate, who was the prime lessee of that 3-bedroom apartment on the Upper West Side, that was back in the day. It was a big building, right? Now I'm sure there are cameras in that building, and if I don't see the prime lessee for 3 months, I might be ready to go to housing court or, you know.
183 days.
Pardon?
183 days.
Yeah. But if I have enough, even if I have enough to have a question in my mind, I can bring them in and start a very expensive legal proceeding, which is another part of the concern. But right now, we're trying to keep getting covered and protected simple.
I mean, we're not going to be able to solve the world's problems here. And you're right, there's no way we can actually get a foolproof, maybe foolproof. But anyway, I think I like the idea just to move forward with this, and I'm sorry, but I'm not sure.
Point. You like that?
I like his point.
Instead of a
Point.
Yes.
His point about the point? Or
Yes.
just the point?
It's point. I mean, listen, man, we're otherwise we won't get anywhere.
Prove it on the defining date, and that's all we said.
Exactly. Exactly. Maybe the answer is through other venues.
I'm going to say that I find Helene's argument a little more compelling to me, that I understand the impetus for the period being through the process.
That is more compelling to you.
It is, so.
It is. I think it is compelling, except.
But I think I'm outnumbered.
No, I'm not saying it's not compelling. It's just that it's probably not.
I think honestly, I can be satisfied with either way for the sake of, I don't, in the scope of the whole thing of all we have to do with these rules, I don't necessarily know that this is the biggest issue. I think I can be comfortable with a line or a point as long as there's some mechanism.
Well, maybe it's a good lens to look at, are we talking about primary residence today? I mean, to just think of the line or point, we kind of, we broke it into that. We know it's only covering that specific moment in time, not forever. It's just.
So that I think, if you went with it's kind of interesting, because if you went with the point and not the line, that actually, I think, would make it even easier for the tenants. Because now, right, because now the standard is that they're a residential occupant, right? The occupant qualified for protection is the residential occupant in possession of a residential unit. So if you go with Chuck's point argument, then they only have to be in possession of the residential unit as a primary residence on the day they file their application.
Well, we could also say residential occupant and then keep the,
And maintain residential occupancy? Yeah, we could do something like that.
Sold.
I don't know.
What does that mean? Maintains
That they
residential-
stay there.
Maintain primary residence.
Well,
Yeah, but that's-
that goes back to a line.
Yeah, that goes to the second.
But maintaining the primary residence is already covered by another rule. The
Another rule,
requirement to
yeah.
maintain primary residence is already covered by another rule.
Residential occupancy.
Okay.
Maintain residential. Residential.
The way it's been done. We've been looking at it.
Well, we have been looking at everything, but we haven't, right.
We're not, you know, here.
I just-
So we just want to look at that.
Different.
We just look at that.
We would have to change it.
And I just want to know, I mean, this is the challenge of not having representation from the landlord side here, whether we have it written as a D or whether we have Mr. Parker being present. I think for folks like myself, it's helpful to have several perspectives to consider. And I think it's a bit of a challenge. I mean, it's not helpful not to have that perspective being
But
presented.
he did actually.
It is, something we need to engage in part of this conversation, because I think you all raised really good points. And I just want to, it'd be helpful, I would say for me, maybe, you know, and for us to also hear other perspectives as well, because I think we're.
So the point here is that this is discussion, and this will be drafted, and then we'll have a chance to.
Right. No, I mean, just the larger issue of not having email here on.
I got you.
I know we voted not to go forward on it, but, you know, for us, I mean.
Actually, it never got to the vote.
Actually, yeah, we never got to that bit, so.
But, I mean,
but even when you're absent, I like hearing the manufacturing point of view. I live in a community where manufacturing is a really big deal in Brooklyn, right near me. So I like having your viewpoint, and sometimes you're absent. And I don't get that viewpoint. So I'm just saying, you know.
No, sure. And so, but I think the option of having a designee who can actually provide that input, you know, I think we've decided not to consider that as an option. And of course, that's still our decision, you know, so that's fine.
There can be other designees.
I think since the chair is always here, the chair should, you know, my point of view should motivate everyone. I think we should move on.
Okay.
So I think what we could do is, maybe we should set this aside for now.
Set it aside.
No,
Wait a
I
second.
think,
Oh, we made a decision?
I think we made progress and you drafted and then we talk about it
Yeah.
I'm
again.
sorry that I got distracted.
Do we have to make a motion or we're not?
I don't know, Elliot's not here, so we're not sure.
Thank God Mr. Allen is not
Decision,
here.
I'm sorry, I missed it.
The board members were still communicating whether they wanted the point or not.
He
So
said-
we got, Mr. Rocha says.
Everyone said point.
Everyone said.
Well,
I
no,
said line.
she said
I'm
lunch.
sorry, with the exception, but she said she acknowledged that
But she
she's.
doesn't count.
She counts, she just outvoted. You still count.
I don't, well,
Mr. Delaney wants the point.
Just to redraft. Well, I think we made some progress. It'd be nice to track it.
I think there's no point to any of this, but I would rather have picked than a line.
Okay. Mr. Hernandez.
I'd be inclined on a line, but I would go to the point not for the purpose of moving forward.
I think there's much to be said about moving forward.
can I make a motion?
Is it a point or a line?
Please make a motion.
Would anybody be interested in a motion that Helene and the staff could draft language for both a point and a line and bring it back to us?
Elaine hates that.
I know she hates that, but it's like, I'm trying to move it forward.
Discussion.
I can't make motions right now.
No, you.
There's a motion on the floor.
No, I asked if I could.
Oh, you can.
Well,
Oh, okay.
don't we have
For
the
this- for
line,
the sake of
isn't the
line-
line,
The line.
the line is drafted?
The line
so
is
I'm just
drafted,
saying,
it's
that's
just a
why
question
I,
of the closing, right? So
Well,
then-
that's what I'm saying, we already have.
so I think where we got some traction was maybe whether it be the point or the line and the continuation of the residential occupancy word left from the whole rule.
I mean, honestly, if we're gonna go that way, we might as well just leave it the way it is, I think.
Could you just say it the way it is right
I
now?
don't think
We just read it. So,
we can.
we can?
In the other case, and the case has already been decided by the board considered on the filing date through the day of the record closes. So
But we-
that would be precedent right now.
But that was for primary residence for a sublessor who was not in possession, which the rule talks about that.
Which case are we talking about?
Hughes.
Oh, you.
He was a sublessor who was not in possession, so he came under B4.
Well, as you know, my contention is the board's made all kinds of case decisions that are at odds with how I read the rule and the way we made decisions for decades. So we occasionally,
Okay, barely.
Okay,
I'm just to make that motion.
I'm going to go ahead and make a motion for the sake of.
Okay.
I'd like to make a motion that the Loft Board staff come back to us with language for both creating a point and enhancing the current language of the line to have a more definitive closure.
So,
In
no-
time.
so you're making a motion that we make no decision today? I just want to talk.
Well, that's kind of a short way to put it, but, I mean, that's in essence what it means.
I mean,
but-
really, I think we don't necessarily need to redraft, because let's assume we kept the language of from the date, through the date the record closes, okay? And for better or worse, we just leave it that way. Then the point would be protected occupancy only if the individual uses the unit as a primary residence on the date the application is filed. That's the point.
But the thing I don't like about the line, the way I'm understanding it now, is I don't like the fact that a tenant is subjected to a lottery of you go first, you go last. The person that goes last has a greater burden than the person that goes first.
That's the line.
That's what I'd like to try to see somehow.
Yeah, that's the line.
That's the
yeah.
line. That's what.
Well, no, I know, but that's what I'm saying. That's what I don't like about it.
Oh, I see.
Is that I feel it's like, okay, so I'm penalized
So
for 6 more years,
so my-
or 3 more years, or whatever, because I didn't happen to go first in the trial.
But that's my point, so let, I'm sorry. this is like really-
But I'm just saying.
But that's the point. The point.
That's the idea.
That's the
That's the
idea,
idea.
that's the idea. So let's get rid of that, because
There has-
I don't like it either.
There has to be some way that we can, I think if we step back and think about it, or redraft that we can still have a line, but it can be more fair across the board.
My point, my thing is, my saying is that I think once you go to the line, it's not, you're never going to find a solution. That's fair.
Right.
Once you do that, you're never going to find a solution. And I'm glad we're debating it, but please don't misinterpret this. I think we're wasting a lot of time trying to come up with something that's going to be completely fair to everybody without acknowledgement of, like Chuck mentioned, a process that will handle some of those unfair situations or situations where people abuse it. So let's leave those to other processes and let's not try to solve the world's problems here.
Can I ask a question?
Yes.
Those thinking about the line, do you have a reason why it makes you more comfortable, the line?
This is a question to Ed.
So my reason for the line was that we've had cases where the people filed their applications and moved out. That's the reason to have the line.
But continue.
Unreasonable to think that during the application and trial process, or the original process, or actual process, that at any, you missed it earlier, or yeah. during the process, it's not unreasonable to think proving you're the primary resident should be, that's not unreasonable to ask.
Versus the current way where it was just a residential occupancy.
Right, it's a residential occupant in possession.
In possession.
That's the current.
Just the assumption you're living, the whole process is about an IMD where you're living. So it's implying, it's like we're creating two hurdles to jump over.
I don't think I think you're right. I don't think it's wrong to assume that you may have to do something else. The problem is, as I see it, is that the person who gets to go first has an unfair advantage over the person.
So there we go, there we go again with that, because I don't think we can solve all that. It's always going to be a scenario where someone gets the advantage. I always wonder about sitting on the front of the plane or the back of the plane, which is better? You get to board first or get off the
But
plane?
in that particular case, you have a choice. You can buy a ticket to sit, make sure you sit in a certain place.
Then you got to spend a lot of money.
I thought you were thinking about safety.
Yeah, well, there's two things, board or plane crashes. But you get my point. I think we're never going to have a level, even playing field in any of this. So we go with what I think is, we go with less, I don't know if it's easier or most fair here.
Are we going to, sideline question, are we going to push past 4:30 today, or are we not?
Depends on what your motion is.
Oh, yeah,
I
right.
think we have a second on the motion.
You don't have a second.
No, I'm actually considering withdrawing my motion if we're going to wrap this up.
I mean, is progress made via the meeting minutes as well as whether you're redrafting this? I mean, I just don't, I think we had an interesting conversation. I don't want to lose it and start again at the same,
Right.
go backwards.
That's why I really wanted to make a decision.
Oh,
I wanted us to really make a decision on this today and get that on the record. So that,
If, for the sake of argument,
and this is, by the way, this is only the draft. And when it comes back to final, we can always.
I don't like the idea of having any point, as I've made clear. If we promulgate a draft rule that has a point, the point of filing an application, when there's a public hearing, we will undoubtedly hear from people who say there shouldn't be any point and it shouldn't exist. And we can hear people who say, no, there should be a line because of X and the line should be whatever. So I don't think it's a bad place, what's the point? I don't think it's a bad place to put the ball in play for public discussion, even though I'm not in favor of it as an end result, but I would support it.
Okay.
So leave it alone and basically leave it as is, as it was before, and just kind of punt it to the future.
Well, no. I think the proposal would be to change what I've written here, only if the individual, this is in number 4 on page 2, right? Only if the individual uses the unit as a primary residence on the date the application is filed. I think that's Chuck's proposal
Correct.
for our point. The way that it is now, we have the line. So we could leave it as a line and get the public comment, or we could leave it as a point.
And you can't
We could
say,
make it into a
and
point.
continue to use it.
We
I
can.
think
So why
maybe
don't-
as a point instead of a line.
Yeah.
So
we go
if
down
it's a
better
point-
maybe switch your motion there. About it. And then I'll second.
Wait, before we go to the motion, can I just clarify what I think Chuck was? So if you say, if individual, the date of the filing of the application, providing that the individual continues to use,
Yeah,
right?
yeah, that will just echo the eviction provision.
Well, yeah, but we can put it in the rule, right, just to make it clear.
That would be
fine?
That would be a place where the debate could begin.
Okay. Did you get the idea?
Yeah, but instead of me trying to make a motion, thinking like Chuck and using Chuck's words, I'm just gonna withdraw my motion.
Okay,
Okay, that I had made, it wasn't seconded anyway.
okay.
And just let somebody that had those words roll off the top of their head properly make it, because that way it makes more sense.
All right, so the motion is withdrawn,
I
and
withdrew my
we're
motion.
going, I need the final language here or something.
Can't you just
fine.
direct the staff to draft it that way?
Yeah, well, did you,
Point?
yes.
Point.
good point.
Okay.
Yeah.
Okay. With that other language to talk about a continuous, or continue to use.
Happy to look at it.
Thank you. Okay, you're good?
I'm good.
Okay.
I have a question.
Yes, sir.
We have a second, we're planning to have 2 meetings in July. And one of those may be a marathon meeting that could start early in the day and go for a significant period of time.
With lunch provided by Ronaldo.
With lunch provided by Ronaldo.
Exactly.
And I
Mr.
want,
Rivera, could you put a purchase order in?
and I want my damn water frozen like you
Is
do.
everybody,
Oh,
Happy all
anyway, yeah.
If it comes to pass that the governor of New York State signs the bill that is on his desk, are we going to continue to look at the limited scope? How do we take that into account with the stuff we've been working on now for quite a period of time?
So, I think our primary responsibility if the governor signs the bill is to work on implementing the bill. That being said, we've made some progress, so my proposal would be to take everything that the board has already, for the most part, agreed on. There are still a couple of minor open issues, particularly Chapter 1, which would allow us to accept electronic filings and get rid of our 5 paper copies, particularly now since we have virtually no filing space whatsoever. And at least incorporate that into a rulemaking, and then do as much as we can of the other stuff as well. So, I mean, I've already been thinking about, what the rules will look like,
I'm sure.
et cetera, and preparing for that, and I hope that the signature comes soon and that we can start moving forward. But that's the idea. So, it will be a lot of material to look over, and I want to get it to you as soon as possible, but it's got to sign.
Our board members, I mean, I know that it's going to be difficult, but are you open to August meeting?
Yeah.
I mean, providing we can
And all
get
day
it
July, I think it's gonna be great. I mean,
all day?
I mean, what,
Well,
10:30 to
10:30,
5 o'clock, that's a day of work for me.
But you can come in the afternoon.
I can do something, just an entire day, or I mean, that's a good chunk.
If you do August,
Maybe that's
Mr.
right.
Chairman, you just have to stay away from
The
the
lunch is not an issue.
Yeah, no, I think we would, be looking more toward the beginning of August than the end of August.
I'm already scheduled to be out of town at the beginning of August.
Yeah,
the
so
beginning
so
of
August is tricky because.
Yeah, right.
It might make more sense to look to September and October to double up again.
Yeah,
Okay.
yeah, we're looking for, we are looking for.
But I guess
but not
what
November.
Helene is saying is, depending on what happens in Albany, that will drive to July meetings. The focus of the July.
Right.
Sure.
Can I ask you a question along those lines? Same one, if it passes in Albany, or if the governor signs it. I don't know, a couple of you have been here for other rollouts of new.
Only Chuck.
I doesn't.
Yeah, I'm sorry, I thought my board.
Yeah, I'm thinking of these two. That what does it look like? We want to do our job right and fast, but also,
So much like these rules, we would take the current rules and we would change them. Let's say, for example, the bill takes out the window requirement. So the rules that have the window requirement, we would put brackets around window, right?
Okay.
Because it's no longer there. So it would look much like these draft rules do, with the brackets and the underlines to make the appropriate changes.
okay.
And then the board would vote We would have to start the CAPA process, which involves publishing, we have a public hearing, probably more than one public hearing, and then the board finalizes the rules and we publish them again. So,
The capital process?
CAPA,
CAPA?
C-A-P-A, City Administrative Procedure Act, that controls rulemaking for all city agencies. If you'd like to see it, I can send it.
Yeah, do you want to send it to
Yeah,
us? 'Cause I'm wondering if we look at the end line and behave, so get to
I mean, it would be the fastest the capital process could go, unless you get a special dispensation from the mayor, is it's like 90 days. Yeah, because you have to publish, and you need at least 30 days before the public hearing, and you have the public hearing, right? And then if you immediately publish the next day after the public hearing, in 35 days.
Yeah, already got it.
I mean,
It's certainly not.
realistically, it's like 40 days, not 40, I think 4 months.
Yeah.
Realistically, but yeah.
4 months is the CAPA process.
No, it's not the capital. The capital process is a process that is normally achieved, I mean, realistically within 4 months. But, New York City's minimum,
Yeah.
realistically. Helene is saying with some urgency, what they call it? Some designation by the mayor.
Yeah, I forget what the exact term
shorten it,
is. If you shorten it, you can get rid of the last 30 days of
But
the
you'd have to
process.
prove that there's an emergency.
Yeah.
Yes.
Slightly off. The event that we had in the building next door some years ago, where we had like a...
280 Broadway?
Symposium, no.
The immigrant savings bank, we opened.
Yes.
Yeah.
Elaine, there was a PowerPoint presentation you presented.
With cultural affairs.
Cultural affairs, yeah. What about it?
Could we look at something similar regarding the concerns that Julie and some of the rest of us have on education for the tenants regarding, Julie, help me out here.
Regarding filing?
Regarding,
Well, there's all kinds of things, sale of rights, but
Sale of rights.
if the new bill passed, my other concern is there's that 9 months for the IBZ, and I don't know when that clock rolls.
No, that clock starts once the law board has promulgated its rules.
Okay. That's
But
good.
is-
That's the way the law
Is a
reads.
symposium like that or something like that feasible? Could we see something like that feasible in the near future?
Or what? What topic?
Is it?
Well, I think the sale of rights.
Sale of rights. Let's see if the governor signs the bill. If the governor signs the bill, I think we're going to be very busy. Okay.
Well, fair enough. I know there's quite a few.
Well, not even, let's say it's not sale rights, but just the fact that it would reopen, you'd want as many
Well, I
citizens to
already
know.
have the coverage scenario. That was in cultural affairs, right? I mean, that was all about getting your application in now and how to do that. That we already have.
So you would run one of those again.
Yeah. we
I mean, I'm
can
just
run it
thinking
over.
there's a lot of people that still
Yeah.
have no idea.
Right,
what's going on.
I know there's several of us on the board that are concerned about the education, providing some additional.
No, absolutely. I
I'll leave
mean,
it- I'll leave it
I
at-
think everyone is interested in that.
I'll leave it.
All right. But we do have some priorities, as you said, but we'll do whatever it takes. Chuck, we're waiting for you. No one had jokes.
Yeah, but we know more.
This will conclude our June 20th, 2019 Loft Board meeting. Our next public meeting will be held here on Thursday, July 11th, 2019 at 10:30 a.m. That's a change at 22 Reed Street, Spectre Hall. Board members, please sign and hand in your attendance sheets. Thank you very much, everyone. Have a happy 4th.